McCully.
Okay. So can you tell me, how did this call transpire? How did you call us?
I walked into the garage. I walked into the garage, and when I walked into the garage, she goes, "Oh, I just did it." And I'm like,
And who was this?
Kiara McCully.
She told you that?
Very calmly and everything, blood on her hands, and
Okay.
I called my mom.
She goes, "Oh, I just did it," very calmly, blood on her hands. And then she called her mom. That is the sentence a Santa Fe County jury heard first, read back, word for word, from a police officer's own recollection of what a young man told him in a strip mall parking lot minutes after he found his friend dead. No names yet, no dates, no charges, just a boyfriend, a garage, and a girlfriend who allegedly confessed to murder the way most people confirm a dinner reservation. Sit with that for a moment, because the person on trial for this killing is not the woman who allegedly said those words. It is the man who repeated them to police. This is the case of the state against Isaac Apodaca, and if you are waiting for the twist, you are already in it. What follows is not a story about a confession. It is a story about whose confession, and why the answer to that question may be the entire trial. On the afternoon of October 29, 2022, patrol officers were dispatched to 5941 Jaguar Drive in Santa Fe County on a report of a possible homicide.
Would you get settled there if you'd begin by introducing yourself to the jury by stating your name and spelling your name for our record, please?
Yes, first name Cesar, Cesar. Last name Ornelas, Ornelas.
Mr. Long. Thank you, Your Honor. Where do you work?
I work with the Santa Fe Police Department.
And how long have you worked for the Santa Fe Police Department?
About 7.5 years now.
And what's your title?
My current title is a police detective with a criminal investigation section.
Okay. How long have you been a detective?
Maybe a little over 2 years now.
So on Saturday, October 29th, 2022, were you on duty?
Yes.
But you weren't a detective at that point?
Correct.
On that day, on October 29th, 2022, what division were you assigned to?
I was assigned to the patrol division as a police officer.
Okay. And were you working daytime, swing, grave?
Daytime hours.
Okay. Did you respond to a call for service on the afternoon of October 29th, 2022?
Yes.
And was that in reference to a possible homicide?
Yes.
Were you dispatched to 5941 Jaguar Drive?
Yes.
And is that address in Santa Fe County, New Mexico?
Yes.
Among the first officers on scene was Cesar Ornelas, at the time a patrol officer with roughly 7 years on the job, testifying now as a detective with 2 years in that title. His assignment that afternoon was simple on paper and chaotic in practice. Secure the perimeter, make sure nobody ran. He went to the back of the residence. He drew his weapon. Not because anyone had told him to expect a fight, but because, as he explained under direct examination, information was still developing, and he had no idea who might come through that yard.
Would you, without saying what anyone said, would you describe for the jury what you did when you arrived?
Upon my arrival, my involvement was scene security and locating the defendant at the time, during the time.
Okay. And did you head towards the back of the residence.
Yes.
All right. And once you were at the back of the residence, what, if anything, did you do?
Initially, it was security for containment, and then I conducted or attempted to conduct a welfare check in the garage.
Okay. When you talk about, I guess, security and containment, would another way to put that be to make sure nobody runs out the backyard?
Yes.
Okay.
That single detail matters more than it sounds like it should. An officer with his gun drawn, jumping neighbors' fences, radio traffic accumulating in his ear, walking into a situation nobody had fully explained to him yet. This is not a controlled crime scene. This is improvisation under pressure, captured in real time by a body-worn camera, the small device clipped to the center of an officer's chest that records both video and, when functioning, audio of everything the officer encounters. That footage would later be marked as State's Exhibits 18, 19, and 20, and it would become the spine of the entire prosecution.
And permission to approach the witness.
Yes.
So, Detective, I'm going to hand you what has been marked as State's Exhibit 18. Would you just take a look at that? Do you recognize that?
Yes.
And is there anything on there that you recognize?
On the city?
Yes.
My signature, dated 7/8 of 2026.
Okay. And have you reviewed that, what is contained on that disc?
On this disc, is my arrival.
All right. And absent the lack of audio, is that a fair and accurate recording of your arrival on that day in question?
Yes.
Before any of it could be shown to the jury, the prosecutor had to do something every piece of digital evidence requires, and few television dramas bother to explain. The officer had to authenticate it, confirm under oath that the recording was his, that he had reviewed it, and that it was, in his words, a fair and accurate representation of what actually happened that day. Only once that foundation is laid, and once the defense declines to object, does a recording become evidence a jury is legally permitted to consider. Here, the defense raised no objection. Twice. The footage came in clean. Before the jury saw a single frame of it, though, the courtroom sat through something almost
And Judge, I think I may need to ask for some technical assistance. Pressing all the buttons and nothing is happening.
It's not in evidence.
Froze.
Judge, at this point, I would move State's Exhibit 18 into evidence.
Any objection to 18, counsel?
No objection from defense, Your Honor.
The prosecutor pressed buttons. Nothing happened. A request for assistance. A hard reboot. A room full of professionals, waiting on a laptop to restart, in the middle of a murder trial. It is a small moment. It is also, quietly, the entire theme of what comes next. Because the case against Isaac Apodaca would ultimately hinge on whether the system built to capture the truth actually did. And in more ways than one, it needed a restart to get there. Once the video played, the jury watched Officer Ornelas move through the alley behind the Jaguar Drive residence and eventually walk into a small shopping plaza a few houses down, AP Wireless.
Okay. I want to talk about this location that you're headed right here. Where is this?
So this is it's like a little shopping plaza, if you want to call it that, where there's businesses there, and that's where the AP Wireless store is located, which is just a few houses down the street from the incident location.
There, he made contact with a man later identified in court as the defendant, Isaac Apodaca. Black suit, white shirt, dark blue tie. The jury was shown, on video, the version of Isaac Apodaca that existed before any of that. A young man in the parking lot, patted down for weapons, told plainly by the officer, "You're not in trouble, bro. We just need to figure this out." He had no weapon. He was calm enough to answer questions, upset enough that the officer would later describe him gently as shaken. And when asked where the injured woman was, he answered immediately. 5941 Jaguar Drive, in the garage. He told the officer he had walked in on her. Then came the part of the recording the entire case turns on. Before asking a single substantive question, Officer Ornelas read Isaac Apodaca his Miranda rights.
You're okay. You're not under arrest, okay? Before I ask any questions, I need you to know this rights, okay? So just listen up. Okay, so just listen up. Direct 98. You have the right to remain silent. Anything you say can be used against you in the court of law. You have the right to consult an attorney before speaking to the police, and you have an attorney present during questioning now or in the future. If you cannot afford a lawyer, one will be appointed before you before any questions if you wish. If you decide to answer any questions now without a lawyer present, you will still have the right to stop answering until you can talk to an attorney. Knowing and understanding your rights, as I explained them to you, are you willing to answer any of my questions without an attorney present?
Yes.
Okay. So let's go over here.
The warning required before custodial questioning that a person has the right to remain silent, that anything said can be used against him in court, and that he has the right to an attorney, appointed if necessary, before or during any questioning. It is one of the most recognizable pieces of American law, and one of the least understood. It does not mean a person is under arrest. It does not mean guilt. It means only that whatever comes next, the person heard it, understood it, and chose to speak anyway. Isaac Apodaca chose to speak anyway. He told the officer his girlfriend was Kiara McCauley. He told the officer she lived with him in the garage. And when asked how the encounter unfolded, he described walking in and hearing her say it herself, that she had just done it, calmly, with blood on her hands. He gave her phone number.
She has a phone number 971.
You want to write this down real quick? Where does she live?
She lives in the main.
For that? Whose phone number is that?
That's the girlfriend, Kiara McCauley.
How do you spell her name?
Kiaramcc.
He spelled her name for the record. He told the officer the woman lying in that garage was a friend of his, named Grace Jennings. This is the moment worth sitting with, because it is the moment the entire prosecution is built on secondhand. A statement made by a defendant to a police officer, describing what someone else allegedly told him. In courtrooms, that layered structure has a name: hearsay. An out-of-court statement offered to prove the truth of what it asserts, generally inadmissible unless it fits a recognized exception. In excited utterance,
a statement made under the stress of a startling event before the speaker has time to fabricate, is one such exception. And it is very likely the theory under which Kiara McCauley's alleged words made it into this trial at all. Not because she said them in court, because Isaac Apodaca did, to a police officer on camera minutes after finding a body. Which raises the question this channel exists to ask calmly, without raising its voice. If the most damaging words in this entire case were spoken by someone who is not on trial, and repeated by the man who is, what exactly is Isaac Apodaca being asked to answer for?
That is where we leave Act 2. Hold that question. It does not resolve for a while, because here is what the jury saw next, and it is worth pausing on before we go further. This is the moment the case actually turned, and it happened not on direct examination, but on cross. The prosecution had built its narrative through Officer Ornelas, the arrival, the search, the discovery, the defendant's own words identifying his girlfriend as the source of the violence. On direct, it plays like a confession by proxy, damning, clean, the kind of testimony a prosecutor wants a jury to walk out of the courtroom still hearing. Then, defense counsel stood up.
I pass the witness.
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
So you, officer, were dispatched to 5941 Jaguar Drive by dispatch?
Yes.
Okay. And dispatch had told you that the female son allegedly told her that his girlfriend had killed another female with a sword.
Yes.
Okay. And when you arrived, officers were were attempting to make contact at the front door, correct?
Yes.
Okay. And you went to the backyard to contain the area?
Yes.
And asked essentially one question, over and over in different forms. What do you actually know? Isaac had no weapon on him. Confirmed. Isaac did not have the keys to the garage where the victim was found, nor keys to any structure at the scene. The only items on his person were a cell phone and a wallet. Confirmed. Isaac did not resist, did not attempt to flee. Confirmed. He was waiting, visibly, at a business a block from the scene, cooperative from the first contact, patted down and cleared before a single question was asked.